You can change your will after it's written as long as you're able to meet the legal requirement. It's typically called testamentary capacity. As long as you have testamentary capacity, you're able to amend and change your will. An amendment to a will is called a codicil. A codicil is an amendment to a will. It's usually amends a few provisions within your will, so you need both documents, the original will and the codicil to the will, to understand the complete picture. Revoking a will legally depends on the state, and it's pretty simple, but we recommend actively revoking a will by signing a document stating that you hereby revoke your will and having that properly witnessed and signed. It's important to make it clear that it's your intention to revoke the will, because down the road, people could argue if your will disappeared that you didn't really intend to revoke it, it just disappeared. And if you intended to revoke it, we want to make sure that that's very clear. It can be necessary to write a new will when you're married, divorced, when you have a big change in circumstances like assets that you may own, or if you want to change the decision makers or the beneficiaries included in your will. There's no limit to the number of times that you change your will. A lot of times our clients will come to us every few years to update their will. Sometimes people go every 10 or so years without updating their will. Other clients will contact us 4 times a year to update their will. It really just depends on your situation and needs. If your beneficiaries change, you should give your attorney a call to make sure that they have the proper beneficiaries listed in your estate plan. Some common scenarios where your beneficiaries might change are marriage or divorce, someone being born into the family, a death in the family, or maybe one of your beneficiaries becomes disabled or has special needs. Those are all scenarios where we may want to change how your beneficiaries receive their assets or make it so they don't receive assets at all. Be careful when making changes to your will. Sometimes we see people handwrite additions or subtractions to their will, and these can have really unexpected outcomes. One example of a case that I read in law school was a person left a gift, a specific distribution. That specific distribution said $10,000 to Sally. The person crossed out $10,000, wrote $100,000 and initialed it. What do you think the outcome should be in that scenario? That they should get $100,000. That was not the case. In this case, that person was disinherited. So it's very important to be careful when updating your will and to follow the proper procedures. If you have any questions about how to make changes to your will, give us a call at ProvenLaw. We're happy to help.